The creation of the British state was brought about by England for its own benefit. It was not some mutual coming together of two states for the benefit of both. It wasn't Scotland, after all, that introduced the Navigation Acts of 1660 and 63, or the Alien Act of 1705, and nor was it England's Parliament that was abolished in 1707. It was Scotland's. For England, the Union was never about abandoning its statehood, as had been the case in Scotland. Rather, they saw it as expanding and enhancing their state through the acquisition of Scotland. Not only did the Union leave it with almost full control of its neighbour, it also provided them with additional land and resources, as well as an enlarged consumer market. It was in essence the ultimate expression of English nationalism. And if England intended the British state to be, in the words of Professors James Crawford and Alan Boyle, an enlarged and renamed England, then this is perhaps the reason why they chose not to define it constitutionally. A written constitution would have cemented in place the fact that the British state was a separate, clearly defined entity from the Kingdom of England that preceded it. Yet this was really about renaming the English state rather than superseding it. And if England considered the British state to be in essence a continuing English state, then naturally they would have expected the notion of parliamentary sovereignty to be inherited by the British state. Yet the idea that parliamentary sovereignty can simply be cemented in place through precedents is moot if the Parliament was never sovereign to begin with. And the use of precedents, or more specifically binding precedents, to declare parliamentary sovereignty over Scotland is contrary to Scottish law, a law protected by the Treaty of Union itself. Moreover, it is also out with the spirit of the treaty, which made no demand on Scotland to transfer its sovereignty. Furthermore, if legal precedent is considered of such importance in determining Scotland's constitutional rights within the UK, then surely the referendum of 2014 has already set the precedent for the holding of a future referendum. And let's be clear, throwaway remarks at the time of it being a once-in-a-generation vote were just that, throwaway remarks. There is absolutely nothing in writing that binds Scotland to being only permitted to hold a referendum just once in a generation. Indeed, the sheer vagueness of the term generation is indicative of this alone. For example, with regard to Northern Ireland, it is stated in the Belfast Agreement that a referendum on Irish unity can be held specifically 7 years after a preceding referendum. No similar requirement exists in Scotland. When politicians in London, politicians, let's be clear, who have never lived or worked in Scotland, choose to ignore or simply brush aside Scotland's right to determine its own constitutional destiny, they serve only to highlight the fact that Scotland is not part of a real union. Rather, the United Kingdom is a faux union, with decisions being made by England and England alone. Ultimately, Scotland's right to choose is being held hostage by a population imbalance that works entirely in England's favour. And we should ignore every false promise of federalism. As we have seen, federalism is highly unlikely to ever happen, and even if it did, it would fail to provide Scotland with many of the powers that similarly sized independent nations have. If the UK was in any way serious about being a British state rather than an English state, then it would cease the practice of prefixing its international agreements and treaties with the word Anglo. Likewise, the Bank of England, the UK's central bank, could easily be renamed the Bank of the UK, or the Bank of the United Kingdom. These are two very small steps that could easily be taken in order to make the UK at least appear more like the union it purports to be. That there have been no serious moves to take these steps is somewhat indicative of the true nature of the Union as a fundamentally English state. In every respect, England is the glaring anomaly in the Union. There is no Secretary of State for England. There is no England Act, like there is a Scotland Act, a Wales Act and a Northern Ireland Act. Its parliament was never abolished. It has 86% of all MPs, meaning it pretty much gets what it wants. So whilst England can prevent Scotland leaving the UK, Scotland can't do likewise for England. The upshot of all of this is that the United Kingdom is a very unbalanced union, favouring its most populous nation at the expense of its smaller nations. Essentially, the UK is not behaving as a union in any real sense, but rather as an English state with Scotland, Wales and Northern Ireland being at best appendages, and at worst little more than colonial outposts. Forcing Scotland to remain in such an unbalanced union is both unjust and undemocratic, and every avenue must be explored to challenge this state of affairs and to reclaim its right to choose its own constitutional destiny. So what now? Well, the first issue that needs addressing is whether a Section 30 order must be obtained in order to hold a legally binding referendum. Certainly, the UK government could simply grant a Section 30 order, yet so far it has refused to do so, and is very unlikely to do so in the near future. Moreover, even if it were to grant a Section 30 order, it's likely that it would only be issued alongside a whole raft of terms and conditions favourable to the Union. The next logical step therefore would be to challenge in a court of law whether a Section 30 order is a legal requirement in order to conduct a binding referendum. As we have seen, Section 30 relates not to referendums but to the Union itself. Yet if the Union is not working as a union, and can be demonstrably shown not to be working, then this may work in Scotland's favour in a court of law. Moreover, as we have seen, both the issue of where sovereignty resides and the constitutional status of Scotland, and indeed the UK itself, have never been adequately defined and remain open to interpretation. In the event that a legal challenge for the necessity for a Section 30 order is rejected in court, then the next step should be for Scotland to prepare to hold a referendum regardless. Much of the preparation for this should also include developing a close relationship with the European Union, so that in the event of a vote in favour of independence, Scotland will potentially have recognition already in place to support its subsequent declaration of independence. Developing such a relationship with the EU should be a relatively easy process. Firstly, Scotland is a predominantly pro-EU nation, and as such stands in stark contrast to the UK state, which is somewhat out of favour in Europe, with trust issues at an all-time low. Secondly, the EU would likely jump at the chance to regain a pro-European part of the UK back into the club. Another aspect that could work in Scotland's favour in garnering support from the EU is the fact that whilst the English judicial system is a common law system, most nations in the EU have civil law. In other words, they have codified judicial systems. A simplistic way of looking at it would be this. Civil law essentially details what you can do and how you must do it. Common law, however, focuses on what you cannot do. The fact that the UK has neither a codified constitution nor chosen to define where sovereignty lies within the different jurisdictions of the state would likely be considered alien by most nations in the EU, where codified constitutions are the norm. And were Scotland to vote for independence, and the UK state chose not to recognise this vote, then these factors may well work in Scotland's favour in helping it to win support and recognition for its independence from outside the UK. The key to any nation's independence comes first and foremost from international recognition. Without this, any independence bid will fail. If the UK state were simply to support Scotland's right to be independent, then this would be an easy process. Yet the UK is currently in the grip of a right-wing English nationalist government, with absolutely no intention of letting Scotland go. Scotland needs to recognise this reality and instead focus its energies on developing relations internationally, because its greatest battle in becoming an independent nation may not be with the UK state, but in achieving international recognition for its independence.